Could we all stand for the national anthem? Thank you very much. Can you just listen now to our safety briefing?
Welcome to the Cipriani College of Labor and Cooperative Studies. You are located at the CLR James Auditorium. There are no planned drills today. In the event of an emergency, you will hear an alarm. Once the alarm is heard, please proceed to the nearest exit, either to the right of the stage or to the back of the auditorium. Once outside, please assemble at the open playing field, where you will receive further directions from the college's emergency response team. Washrooms are located to the right of the stairs as you exit the auditorium, or to the left of this stage. Be reminded that this is a no-smoking facility, and do enjoy your stay at the college.
Right. Good afternoon and welcome. Welcome to those of you here with us at the auditorium of the Cipriani College of Labor and Cooperative Studies. And a special welcome to you who are online as we all participate in this discussion on the Guyana-Venezuela border controversy, perspectives from Guyana. Let me pay my respects to the director of the college, Dr. Andre Vincent Henry. Let me say welcome to our panelists, Dr. Raymond Mark Curtin, Dr. Gary Bess, and our feature presenter, Mr. Carl Greenidge. My name is Adriana Archer. I am the Program Dean for the Security Administration and Emergency Management Department at the Cipriani College of Labor and Cooperative Studies. I am your moderator for this afternoon's proceedings. Permit me to also recognize Dr. Marlon Anatol, our Dean of Research here at our college. So, our first panelist for this evening's proceedings will be Dr. Raymond Mark Curtin. A little bit about Dr. Curtin. He is a citizen of Guyana and the holder of a Bachelor of Arts with distinction from the University of Guyana, a Master of Science from Georgetown University, Washington, D.C., and a Doctor of Philosophy from the University of Texas at Austin, USA. His professional experience spans more than 4 decades of university teaching, research, and administration. At the University of Guyana, he served as senior lecturer and head, Department of Political Science and Law, later becoming the Department of Government and International Affairs, also head of the Graduate School of the Social Sciences, Assistant Dean, Faculty of Arts, and Dean of the Faculty of Social Sciences. Dr. Curtin later joined the University of the West Indies and served as Acting Director, Institute of International Relations, the University of the West Indies, St. Augustine, Trinidad, from where he retired. He is currently an honorary senior fellow at the Institute of International Relations at the University of the West Indies. In 2017, he received a national award, the Golden Arrow of Achievement from the Government of Guyana, for his contribution to higher education and regional integration. He has published several referred book articles and book chapters and has co-edited books including Governance, Conflict Analysis, and Conflict Resolution with Cedric Grant, selected essays on contemporary Caribbean issues and international relations perspective with Dr. Marlon Anatole, contemporary issues in Caribbean and Latin American relations with Dr. Marlon Anatole, and the changing political and socio-economic environment in the Caribbean and Latin America, prospects and challenges, with Paulo Gustavo Correa and Dr. Marlon Anatole. He also co-authored with Kellon Roach, A History of the Institute of International Relations, 50 Years and Beyond. His most recent book, Building Bridges in the Amazon, Guyana, Brazil into the 21st Century, is available in English and Portuguese. Dr. Curtin's current research interests include regional integration, Latin American politics and government, and migration, and human security. Ladies and gentlemen, it is my pleasure to introduce Dr. Raymond Mark Curtin to the microphone.
Thank you very much, Madam Moderator. Good afternoon, ladies and gentlemen, Excellencies of the Diplomatic Corps, distinguished members of the audience, both in person and online. Let me first express my gratitude and appreciation to the director and staff of the Cipriani College of Labor and Cooperative Studies for this important initiative, which is aimed at discussing several dimensions of the Guyana-Venezuela border controversy and presenting perspectives from Guyana, while at the same time sensitizing our Caribbean brothers and sisters on this important issue, which relates to the protection and maintenance of Guyana's sovereignty and territorial integrity. I'm happy to be back on this beautiful island, which I called home for more than a dozen years. And it is significant that we are discussing this critical regional issue not only in the country where the Treaty of Chaguaramas was signed, but in the country that is the lead country on security issues in the CARICOM quasi-cabinet. In order to place this issue in context, it's important to provide a historical review on which I've been asked to focus today, which begins with the situation in which, in 1841, the Venezuelan government protested alleged British encroachment on its territory after the British had commissioned Robert Schomburg, a surveyor, who had delineated the boundary which was established on what became known as the Schomburg Line. For several years thereafter, and disagreements which arose, Venezuela appealed to the United States for assistance, in a sense under the Monroe Doctrine. And by 1895, based on further disagreements, the US and Britain agreed on the establishment of the Anglo-Venezuelan Arbitral Tribunal under the Treaty of Washington of 1897. Under the terms of this treaty, Britain and Venezuela agreed, and I quote, to consider the issues of the tribunal arbitration as a full, perfect, and final settlement of all questions referred to the arbitrators, end of quote. In October 1899, in the unanimous decision, the tribunal described the boundary which was established as, quote, a line based on equity and law, end of quote. It was clearly noted at that time that both Britain and Venezuela were in full agreement, and the boundary which was determined by the tribunal was surveyed, and the markers defining the boundary were put in place by a mixed British-Venezuela Boundary Commission, and was thereafter reflected in the 1905 Boundary Agreement between Britain and Venezuela. It is also significant that in 1931, Venezuela, Brazil, and British Guyana met and marked the point where the British Guyana-Venezuelan boundary line, established in 1899, met the boundary with Brazil. This area was then named the Tri-Junction Point, and this action also indicated full agreement by all parties. Indeed, a physical marker was placed, and the pillar had the full agreement of all parties, and as noted by the then Venezuelan foreign minister, the Tri-Junction Point, and I quote, recently determined and marked with a pillar by the commissions of the three countries, gave clear proof of the spirit of justice, good faith, and cordiality, which animates its actions in the conduct of international relations, end of quote. It is also important to note here that Brazil, which settled its borders with then British Guyana since 1904, has maintained its position until today that borders which have been settled through the judicial process are inviolable. And as its analysts have noted, the historical process of Brazil's international action, which included the settlement of its borders, have been based on pacifism, knowledge diplomacy, and confidence in international law. And this has undoubtedly led to its consistent position on the sanctity of settled borders. Madam Chair, it is also important to note that based on the defined and accepted boundaries awarded by the tribunal in 1899, both Venezuela and Guyana exercised full rights of jurisdiction in their respective territories until 1962, when, with Guyana approaching its independence in this period of decolonization, Venezuela unilaterally declared the arbitral award to be null and void and moved its claim to the territory west of Guyana's Essequibo River to the United Nations. It is also instructive to note that Venezuela raised the territorial claim not only when Guyana was pursuing its path to independence, but in a raging Cold War environment in which the United States was clearly moving to present its opposition to the possible ideological radicalization of the region in the midst of what might be termed anti-communist hysteria, which was present at the time. One notes that when Venezuela first presented its purest contention, one of the major arguments as the basis of invalidity of the arbitration award of 1899 was a memorandum written by a lawyer, Severo Male Prevost, who had appeared as part of the Venezuelan legal team during the sittings of the tribunal in 1899. It was claimed in a memorandum in 1844, which we instructed to be published posthumously, that the award was a result of collusion, allegedly among some of the judges of the tribunal. As far as it can be ascertained, no evidence has ever been presented by Venezuela in support of this claim. In November 1962, a group of experts was established, and the group indicated that there was no evidence to support the contention of nullity. But even in the face of clear evidence, Venezuela remained unconvinced. As a result, Britain, British Guyana, and Venezuela signed the Geneva Agreement in 1966, which stipulated a process which the parties would allow for a period of 4 years to resolve the controversy. A mixed commission was established, but this effort to resolve the controversy was unsuccessful, and one could argue here that its work was constrained during this period, since acts of aggression by Venezuela were carried out, including the occupation of Guyana's half of the Ancocco Island, the signing of a decree by President Leone of Venezuela to annex part of Guyana's maritime zone, and public statements by Venezuela objecting to any developmental activity in the Essequibo region. One could argue here that these actions undermine confidence in the process, and as a result of the lack of success of the mixed commission, another attempt at resolving the controversy came in 1970, when Trinidad and Tobago, under Prime Minister Dr. Eric Williams, brokered the signing of the Protocol of Port of Spain. It is also not without significance that at that time, in 1970, as a matter of fact, on February 23rd, 1970, as Guyana was celebrating its move to the status of a republic, Guyana's soldiers at Itaring Bang on the Guyana border were under a barrage of heavy fire from the Venezuelan military and had to initiate a hasty tactical withdrawal. Such was the level of aggression by Venezuela even at that time, even when there were negotiations and dialogue taking place. I digressed here, but under the terms of the Protocol of Port of Spain, it was to remain in effect for 12 years, renewable for successive periods, each by agreement of the governments. It was envisioned that for a period of 12 years, efforts would be made to promote friendly relations between the two states, and it was seen as a valuable mechanism to provide an opportunity for de-escalating the tensions between the two countries and allowing for dialogue and the freezing of the claim and for the parties to seek new levels of rapprochement during this period. By the time of its expiration in 1982, Venezuela had indicated its unwillingness to renew it, and this period coincided with renewed tensions, during which time Venezuela used its influence internationally to block World Bank financing for Guyana's hydropower development program, and also influenced the exclusion of Guyana from concessionary oil agreements, which were offered to other CARICOM states and Central American states at the same time. The expiration of the protocol meant that another effort settling the controversy had to be sought, and both parties decided to refer the issue to the Secretary General of the United Nations. It must be noted here that within the framework of the 1966 Geneva Agreement, the United Nations Secretary General was empowered to utilize what is termed his good office, generally meaning his prestige and the weight of the world community he represents, in an effort to prevent the international controversy from escalating or spreading. The Secretary General conducted the good office's process from 1990 to 2017, aimed at securing a solution to the border controversy. In the absence of resolution and after much dialogue, the government of Guyana in March 2015 approached the Secretary General to act in accordance with his obligation under the 1966 Geneva Agreement and choose another of the means of settlement to the controversy, which is stipulated in Article 33 of the United Nations Charter. Guyana articulated its preference for a judicial settlement at the time, calling for a final and binding decision in relation to Venezuela's contention that the 1899 arbitral award is null and void. The then Secretary General Ban Ki-moon presented to the parties in December 2016 a framework for the resolution of the controversy and indicated that the good officers process would continue for one final year until the end of 2017 with an expanded and strengthened mandate of mediation. Both parties were clearly notified that in the absence of significant progress made towards reaching a full settlement for the solution of the controversy, the Secretary General would choose the International Court of Justice as the mechanism for a settlement. It is interesting to note, and important also, that in January 2018, Secretary General Guterres, after comprehensive assessment of the issue, chose the ICJ, and based on the decision of the Secretary General, Guyana filed an application to institute legal proceedings with the ICJ in June 2018. It is also instructive to observe that in June 2018, the ICJ received communication from the government of Venezuela that it would not participate in the matter, even though the Geneva Agreement provided the Secretary General with the authority to choose that court as the means of conclusive settlement in the matter. The issue of the court's jurisdiction, raised on 2 occasions by Venezuela, saw a ruling by the court that it had legal authority to adjudicate in the matter. The issue in relation to the validity of the 1899 award is currently engaging the attention of the court. Madam Chair, these references to the historical antecedents and to the efforts of dialogue means, and I think it is important that in spite of the treaty organizations, judicial interventions, and strong dialogue, Venezuela since 1966, through its acts of aggression, has significantly impacted the economic development of Guyana. And as we mentioned, one could recall that at independence in 1966, an incursion by armed Venezuelan soldiers and civilians took place on the Guyana side of the Ankoko Island. And thereafter, acts of aggression have included, but not limited to, incursion into Guyana's territorial space, the seizure of Guyana's fishing vessels, the arrest of a vessel conducting seismic surveys in Guyana's exclusive economic zone by Venezuelan naval forces, as well as threats against companies engaged in economic partnership agreements and arrangements with the government of Guyana. One could also recall that in May 2015, there was a decree number 1787, which declared Venezuelan sovereignty over Guyana's maritime space adjacent to the Essequibo coast. And this decree threatened the sovereignty of several neighboring CARICOM states, including Suriname, Trinidad and Tobago, and Barbados. And while under international pressure the decree was withdrawn, it was succeeded by Decree 1859, which merely removed coordinates related to the maritime zone. We've also seen Decree 4415, and so there's been a range of aggressive action by Venezuela for more than 60 years in pursuit of its purest claim to Guyana's territory. We have now witnessed the Maduro government's current action, unprecedented, to hold a referendum and move to reignite unity and patriotism and a coalesced political platform in relation to the territorial claim, and in this process, gain new levels of legitimacy internationally, built on that demonstration of national unity. One can also not discount the emergence of the new oil and gas sector and its potential link to this re-emerging unprecedented action by Venezuela. As I listened to Guyana's agent of the ICJ, Mr. Carl Greenidge, who is a member of our panel, and Mr. Paul Reichler, the Counsel for Guyana, make their presentations last week, at the ICJ hearings on the Venezuelan referendum, there were significant concerns which were raised, and these must be added to the existential threat which we currently face in Guyana. Mr. Greenidge cited the potential irreparable loss of Guyana's territory, which may occur as a result of annexation by Venezuela. Mr. Reichler presented evidence of the preparation of Venezuelan military personnel to, quote, defend the annexation of its new state of Guyana Essequibo after the referendum, as well as the preparation of a military airfield close to the Guyana border, which, according to Venezuelan military commanders, whom he quoted, will serve as a logistical support point for the integral development of the Essequibo. I also listened to a television interview by Venezuelan Vice President Delcy Rodriguez, who not only claimed that Guyana was an aggressive state, a predator of natural resources, and a violator of international law, but in an answer to a question, said that after the referendum's affirmative vote, Venezuela will present Venezuelan identity cards to citizens in the Essequibo, which suggests a Venezuelan presence on the ground in that region in the post-referendum period. These actions by Venezuela demand immediate resolution, and we see some of them as significant fabrications in that process. In my respectful view, with diplomacy continuing to be Guyana's first line of defense, it can be argued that given the current unprecedented level of aggression and the statements related to possible armed intervention and annexation, Guyana should immediately approach the United Nations Security Council to inform that body, since it is clear that under Article 34 of the United Nations Charter, which states that the Security Council may investigate any dispute or any situation which might lead to international friction or give rise to dispute, that kind of process could be adopted. And we also see Article 35 of the United Nations Charter, which indicates that any member of the United Nations may bring any dispute or any situation of the nature referred to in Article 34 to the attention of the Security Council of the General Assembly. And I would support the view that it is necessary at this point to bring to the attention of the Security Council this existential threat which remains. Additionally, given the clear and present danger to the Guyanese citizenry, I think that there should be an immediate special meeting of CARICOM heads, especially in the context of the rising tensions and Venezuelan troop movement amidst statements about annexation, and with the security of member states being part of the fourth pillar of regional integration enshrined in the revised Treaty of Chaguaramas, CARICOM, led by the state Trinidad and Tobago, which has responsibility for regional security, should actively consider the enlargement, the widening of the regional security system, which Guyana recently joined, and establish a military observation mission to Guyana. At the same time, in my view, CARICOM should consider joining Guyana in a joint approach to the United Nations in this regard, with an expanding regional security system in support of local Guyanese forces as a multinational force which can act as a deterrent to possible incursion on Guyanese territory and prevent loss of life, and especially in the border communities. Madam Chair, it is not without significance that Guyana's neighbor, Brazil, has gained much experience in the region, especially as a result of its participation in the military humanitarian mission in Haiti, MINUSTA, under the aegis of the United Nations, and with its diplomatic tradition of respect for borders and international rules, there should be urgent and sustained interaction with that country to add its weight in this strategic engagement to ensure that the borders of Guyana remain inviolable. Madam Chair, let me reiterate that the action by Venezuela demands the attention of the international community, and our brother and sister states in CARICOM must be in the forefront of the effort to clearly advocate for sustained international action in the face of this threat to Guyana's sovereignty and territorial integrity. Guyana must also engage regional groupings, such as the Caribbean Media Workers Group, CAMWORK, the regional universities, and other groups and institutions. And once again, I want to congratulate this initiative from this college. And I think since it necessitates that the regional populace be sensitized on this issue, and so that it can promote greater understanding of the threat faced by its sister state. Additionally, the Association of Caribbean States, located in Trinidad, which has its genesis in the work of the West Indian Commission and the important report Time for Action, must also now be engaged in the regional effort, especially in the context of its adherence to the view that the region must continue to be a zone of peace. Further, the Community of Latin American and Caribbean States, CELAC, which Guyana participates not only as one of the quartet of countries of CARICOM, coordinating the 33-member grouping, but CARICOM now serves as its pro tempore chair, in the person of Prime Minister of St. Vincent, must also be integrally involved in the promotion of and adherence to the rule of law and peaceful resolution of controversies through internationally established judicial institutions. But perhaps the most important approach to be enhanced by Guyana is the sensitization of its own citizenry in order to avoid misinterpretation, information deficits, and the emergence of speculation. This will ensure that the nation continues to speak with one voice. I therefore call on my Caribbean brothers and sisters to actively advocate for unequivocal support to be extended to Guyana at this critical juncture. There's no doubt that recognition of individual states' national interests must be understood, but the threat to the territorial integrity and national sovereignty of one state demands full and unequivocal support from its sister territories. I therefore wish to be associated with the position of Guyana, supported by both government and opposition, that it considers that the only appropriate forum for Venezuela to raise its territorial claim, consistent with the rule of international law and the preservation of peace and security, is the International Court of Justice in The Hague, which has already twice determined that it has the jurisdiction to resolve the claims made by Venezuela. Further, as Guyana has noted, resolution by the court assures both parties of a final, binding, and permanent settlement that is equitable, just, and consistent with international law. Madam Chair, while some of us would like the rhythm associated with the calypso called Do You Want With We, all Guyanese and our friends everywhere must not only sing along with us, Not a Blade of Grass, but commit to join us as active participants as we not only sing, but act, since we ain't giving up no mountain and we ain't giving up no sea. I thank you, Madam Chair.
We are a peaceful people, struggling we struggle, and we don't look for trouble, just ask around. But when outside faces foreign places. Talk about taking over, we ain't backing down. No, we ain't giving up no mountain.
Thank you very much, Dr. Curtin. I know you could have gone on a little more, but time, we have to watch time. So thank you very much for sharing your perspective on this controversy between, Venezuela and Guyana. Our next speaker for this afternoon is Rear Admiral retired Gary Anthony Rodwell Bess, MSS. A little bit about Rear Admiral retired Anthony Rodwell Bess. He is a former Chief of Staff of the Guyana Defense Force and an attorney at law. He holds a PhD in International Relations from the University of the West Indies and an MSc Global Studies, UWI, a master's degree in law, LLM, UK, and a bachelor's degree equivalent to nautical science from Brazil. Rear Admiral Bess is also an alumnus of the National Defense University, USA, the Harvard Kennedy School of Government, USA, and the Frankfurt School of Finance and Management in Germany. He has considerable experience in maritime law, strategic studies, defense, and national security. He is a former presidential advisor on the environment and a past columnist with the Guyana Chronicle on green economy matters. Rear Admiral Bess has presented several academic papers at conferences hosted by the Institute of International Relations, the University of the West Indies, the University of Guyana, and the LIRDS think tank group, the University of Havana, the Anton de Kom University in Suriname, and the Australian National University. A staunch advocate of national defense, national security, and good governance, Dr. Bess is the leading voice for safeguarding Guyana's patrimony in the current crisis in Venezuela. Ladies and gentlemen, my pleasure to introduce Rear Admiral retired Gary Anthony Rodwell Bess.
Thank you, Madam Chair. Madam Chair, please permit me to stand on the protocol established by Dr. Curtin. Comrades all, illegal occupation, inalienable rights, and indivisibility of the Guyana state. I wish to begin with an undisputed fact, that is, the Bolivarian Republic of Venezuela, commencing in 1966, has been and continues to illegally occupy land in the sovereign county of Essequibo in the form of the total occupation of an island called Ankoko, half of which belongs to Venezuela and half of which belongs to Guyana. So as we speak and as we look at what is happening in the ICJ, Venezuela is occupying our territory. This, in essence, was Venezuela's gift to Guyana, which it attained in 1966, May 26. To this action, Madam Chair, the government of Guyana filed successive objections via the international portals, and Venezuela's response was to remain in occupation. All of Guyana's territory, to which I shall refer, sprung from the 1899 arbitral award, which was and is a full, final, and perfect settlement of the borders between British Guyana, the UK, and Venezuela, and from 1966 between the Cooperative Republic of Guyana and the Bolivarian Republic of Venezuela. With regards to the Cooperative Republic of Guyana's territorial integrity, Article 1 of Guyana's 1966 Constitution puts the matter of territory thusly, and I quote, "The territory of Guyana shall comprise all the areas that, immediately before 26th of May 1966, were comprised in a former colony of British Guyana, together with such other areas as may be declared by Acts of Parliament to form part of the territory of Guyana," unquote. Article 1.2, as I just read, is consistent with international law in the extent that Guyana, as a newly independent state, became a successor state, the territory of which, British Guyana at the time, immediately before independence, became a successor state. British Guyana was a dependent territory, and for international relations, those were conducted by Britain. As a successor state, Guyana became responsible for its own sovereignty. The Cooperative Republic of Guyana, at independence, and thenceforth became fully responsible for conducting its own international relations among nations, in particular, sovereignty over its territory. That territory succeeded from the United Kingdom. Madam Chair, allow me to point out at this juncture an important fact, which is a successor state can invoke before a tribunal all grounds of claim or objections which could have been invoked by the United Kingdom in the defense of British Guyana. Further, the extent to which the United Kingdom exercised sovereignty over British Guyana, to that extent, Guyana, the successor state, exercises sovereignty over that same territory. In conformity with Article 1.2 of Guyana's 1970 Constitution, the description of the territory is exactly the same, never changed. The same reasoning as the successor state therefore applied to the Guyana 1970 Constitution, which created the Republican state. Further, Article 2 of the Cooperative Republic of Guyana's 1980 Constitution, as amended, puts the matter of its territorial integrity thusly. It says, and I quote, "The territory of the state comprises the areas that immediately before the commencement of this Constitution, that is the 1966 Constitution, were comprised in the area of Guyana together with such other areas as may be declared by Act of Parliament to form part of the territory of the state." Most importantly, Article 1 of the Cooperative Republic of Guyana's Constitution, as amended, put the matter of its territory in the following manner. Guyana, and I quote, "Guyana is an indivisible state. This means that the territory cannot be divided." Madam Chair, allow me to make 3 additional but critical territorial integrity points. The first one, in addition to the indivisibility of the territory of the Republic of Guyana, nothing or none of its territory can be subtracted. But additions to it are contemplated, as expressed by the following words immediately above. This is part of what I quoted before, which says, "Together with such other areas as may be declared by acts of Parliament to form part of the territory of the state." When I read the Constitution and I interpret it, we cannot subtract territory, but there is provision for adding of territory. Secondly, Article 2 of the Republic of Guyana's Constitution, as amended, can only be amended by a national referendum. This is a continuation of the deeply entrenched nature of the territory of Guyana. Both the 1970 Constitution and the 1980 Constitution, as amended, deeply entrenched that territory. The point I'm making here, Madam Chair, is that Guyana has never attempted at any point in time to have any territory greater than that it received from the United Kingdom. Thirdly, the Republic of Guyana consistently declared in successive constitutions only that territory it received at independence from the United Kingdom. Guyana conducted no type of hegemonic acts against the territory, against the people and territory of the Bolivarian Republic of Guyana, of Venezuela rather. In contrast, the evidence showed that Venezuela has and continues to be that nation-state aggressor. In view of the above, I posit that the borders of the Republic of Guyana are sacrosanct, indivisible, inalienable, and therefore non-transferable. Interestingly, during my research, I looked at Article 10 of the Constitution of the Bolivarian Republic of Venezuela. And in its constitution, it puts the matter of its territory in this manner, and I quote, "The territory and other geographical spaces of the Republic are those which belong to the Captaincy General of Venezuela before the political transformation begun on April 19, 1810, as amended by virtue of the treaties and arbitration awards which have not been vitiated with nullity," end of quote. In my view, the words "as amended by virtue of the treaties and arbitration awards which have not been vitiated with nullity" are of crucial importance in that the 1899 arbitral award, which is a full, final, and perfect settlement of the boundary between Guyana and Venezuela, has been and has not been vitiated with nullity. In fact, the 1899 arbitral award remained acceptable to Venezuela in accordance with its own constitution, which is Article 10. For context, Madam Chair, Venezuela became independent on the 5th of July, 1811, 88 years before the 1899 arbitration award. And for context also, slavery ended in Venezuela in 1854, 43 years after its independence. Importantly also, the Republic of Venezuela comprises 23 states, none of which is the territory of Essequibo. This speaks to the consistency of the territory of Venezuela never comprising the territory of Essequibo over the history of the Venezuelan state by its own constitution. I wish to turn to the term hegemony by a state. Apparently, without any concern for international law, particularly the UN prohibition of the threat or use of force and respect for territorial integrity and political independence of any state, the Bolivarian Republic of Venezuela prefers to resort to bellicose rhetoric and what the legal luminary, the Guyana team, refer to as legal guerrilla warfare. Its only intention is to intimidate the nation state of Guyana, and that it has been doing for decades. Venezuela's actions are consistent with hegemonic conduct by a great power in pursuit of its objectives. So how does the hegemon operate? An important characteristic of the hegemon is an active demonstration that its interests must become the interests of all, referred to as hegemonic control. Venezuela has consistently misrepresented that the Geneva Agreement governing itself and Guyana only provides for bilateral dialogue to address the border controversy, surrounding the full, final, and perfect settlement by way of the 1899 arbitration award. This is patently false, and I know the agent for Guyana will speak extensively on this. However, this is patently false for the action of a hegemon, and the action of a hegemon rather. It is odious for the Bolivarian Republic of Venezuela to try and convince particularly the learned, Guyanese in general, the citizens of Latin America and the Caribbean, international governmental organizations, among others, that the Geneva Agreement was intended for Guyana and Venezuela to determine the validity of the 1899 arbitration award. That is a matter for the court at this present moment. It is beyond preposterous, but it's consistent hegemonic behavior. Venezuela, Madam Chair, is constantly infusing contradictory discourses in an effort to exercise ontological, epistemological, discursive hegemony. As Seth puts it, the hegemon reproduces power relations characteristics of its colonial encounter. One wonders, therefore, whether Venezuela's successful war of independence created a superior-inferior dominion within its body politic when it comes to a far lesser power, or in this case, far lesser powers. In this context, Venezuela seems to disregard the important role international regimes and institutions play in increasing the prospects of cooperation and outcomes in a given issue area. In this context, United Nations is a critical example. The consistent presidential decrees by Venezuelan heads of state threatening and interfering with the settled boundary between Guyana and Venezuela is a reflection of a foreign policy towards the Republic of Guyana that is more realist than neoliberalist. In this context, Venezuela seeks relative gains, which lead to, among others, balance of power and hegemonic dominance. In other words, a zero-sum game is the outcome. Further, the recent announced referendum by Venezuela purporting to annex the Guyana Essequibo territory, along with threatening statements from its president, ministers, military commanders, and vice presidents, fits into classical hegemonic conduct. As posited by Mersheimer, there is little evidence that institutions can convince the great powers to act against the dictates of realism. This seems to be the class into which Venezuela has put itself when it comes to Guyana, a great power purported to dictate the fate of a much lesser power. A significant point to note, however, is none of these actions by Venezuela is consistent with the principles of Bolivarianism, as I read them. A fair question therefore arises: is Venezuelan hegemonic conduct towards Guyana an outlier, or do other threats await the region as it seeks to manage collective goods in and for this region? The hegemon also pays for influence. As pointed out by Hassan Clever, the hegemon also helps states by making side and direct payments to them in order to secure cooperation. In my view, the Petro-Caribbean Initiative is being used by Venezuela as a suasion tool, rather, to secure the cooperation of an otherwise influenced CARICOM states to be at least ambivalent in the support to Guyana's territorial integrity, which is threatened by Venezuela. We heard a call from Dr. Corton for full CARICOM support. Venezuela, in this sense, pretends to be a benevolent hegemon. Therefore, statements that call for Guyana, the non-aggressor, and Venezuela, the aggressor, to ensure that the region remains a zone of peace, suggest the heeding of the wishes of the hegemon for fear of losing an economic benefit. A question that naturally arises, meaning, for example, are these what Cox calls hegemonic orders that are being presented to us in the Caribbean? Are they designed for compliance by other states within the Caribbean? CARICOM, on the other hand, and I don't pretend to be an expert in CARICOM, but CARICOM, on the other hand, as an international regime underpinned by institutional bargaining, ought to function as a counter to hegemonic counter by Venezuela against Guyana and any other country in the CARICOM. So, Madam Chair, what might be Venezuela's ultimate objective? And in this particular instance, it could be an alternative objective. When I analyze the dangerous and bellicose language used by Venezuelan officials in support of its referendum on Essequibo, and the fact that of the 23 states in its constitution, there is no Essequibo, it is not beyond reason that such alarming actions may well be a ruse for President Maduro via the expected yes result to question 5 of the referendum, which is to annex Guyana, to subsequently argue that he has a mandate to incorporate Essequibo into the Venezuelan constitution. That might be a plan that Mr. Maduro has. The Venezuelan threats to Guyana and its response, and I'll just be brief. I begin this portion by adopting the views of Professor Griffith, who submitted, and I agree with him, that Venezuela's referendum and spurious claim undermines 4 key factors of nationhood: land, people, resources, and identity. And this is not a threat only to Guyana. Any hegemonic movement, those are the 4 pillars of nationhood that will be threatened. In other words, Venezuela's 5-question referendum is an attack on Guyana's national security, national interests, and national values. In short, the nation's national patrimony. Further, looked at historically, Venezuela has always posed an existential threat to Guyana, given its history of operating as an economic hitman against the nation state of Guyana. Guyana's response and challenges. Over the past 6 decades, the Cooperative Republic of Guyana depended firstly on defense diplomacy. We never sought to build military resources to be equivalent to Venezuela. And our military defense diplomacy was underpinned and driven by Article 37 of our Constitution, which reads thusly: the state supports the legitimate aspirations of other peoples for their freedom and independence, and will establish relations with all states on the basis of sovereign equality, mutual respect, inviolability of frontiers, territorial integrity, peaceful settlements of disputes, and non-intervention in internal affairs. Madam Chair, clearly the actions of Venezuela offend Guyana's constitution and its patrimony contained therein. As I pointed out earlier, Venezuela's own actions are also contrary to Article 10 of its own constitution. Concomitantly, Guyana subscribes to the sanctity of treaties in accordance with international law and has conducted its foreign relations with this as a primary objective within the boundaries of Article 37, which I just read. The second aspect concerning Guyana is the concept of total national defense. This is where the total national material and human resources are organized and deployed to achieve total national defense. In defense of the country's territorial integrity against external aggression. Further, Article 33 of the Constitution, also deeply entrenched, states it is the duty of every citizen to defend the state of Guyana. So we made provisions for all of the citizens to be in part in this territorial and national defense. Thirdly, under the threat of annexation, which is the current situation, an increased influx of Venezuelan nationals, amongst whom are possible agents of destabilization, is a concern right now in Guyana. It is difficult to imagine that there's someone threatening you to annex you, and the people who come from that person's country do not include agents, do not include forward elements. Increased bilateral and transnational criminal networks. We're faced with that, and by extension, the region. A criminal triumvirate involving Guyana, Trinidad, and Tobago, and Venezuela is a real possibility. That triangle that we spoke about earlier. Some regional implications as I close. Territorial integrity or territorial integrity instability via change of land borders within South America. Dr. Courtney referred to that, those borders, the possible change or the position of Brazil not to have a change. In this context, the tri-border point between Guyana, Venezuela, and Brazil, that's very important for us. Any change there, a possible change here, destabilizes the region. But the possibility of dormant border issues within South America becoming issues once again should be a concern for us geopolitically. Secondly, maritime integrity instability, with a change of maritime boundaries within the Southern Caribbean space, particularly since Venezuela has maintained a reservation on Article 15 of the United Nations Convention Law of the Sea. And that convention provides that in the event of a disagreement between two adjacent states, such as Guyana and Venezuela, and of course Venezuela and Trinidad, in that case it was opposite states, on the delimitation of their territorial seas, the boundary shall be the application of the equidistant line principle unless an historical title permits variance. Madam Chair, the 1899 arbitral award fixed the land boundary between Guyana and Venezuela. And Guyana has applied the equidistant principle to delimit its maritime boundary, which springs from its own land boundary under the only fact, and that is the 1899 arbitral award is full, final, and perfect settlement of the border between Guyana and Venezuela. But as I said, Venezuela submitted a reservation to Article 15 of this convention. New conflicts and maritime delimitations are likely. Potential arms race buildup in the region is likely. And an increased cost of doing the people's business are definite consequences if this matter is not settled peacefully within the courts. Madam Chair, finally, an increased role for the regional security system perhaps could be an outcome. And by extension, increased per capita defense costs and its negative effects on positive growth in the region. Madam Chair, I will stop at this juncture and thank you all for listening to me.
Thank you very much, Dr. Bess, for that. That was very, very enlightening. We had Dr. Curtin giving us almost the historical aspect of this controversy between Guyana and Venezuela. And then we had you coming forcefully behind with your legal arguments. So thank you very much for that, Dr. Bess. Before I introduce our feature speaker, I would like to ask the director of the college, Dr. Andre Vincent Henry, to say a few words. Or you'll do after? Okay, all right. Things going nice, eh? That's why, eh? Yeah, good conversation. Okay, so ladies and gentlemen, our feature speaker for this evening is Mr. Carl B. Greenidge, Esquire, who is a former Vice President of the Cooperative Republic and is currently the advisor on borders and agent to the ICJ in the case concerning the validity of the 1899 Paris arbitral award between Guyana and Venezuela. He has been a ministerial spokesman as well as a lead negotiator of teams that successfully negotiated commodity protocols, cooperation and development finance agreements on behalf of Guyana, CARICOM, and the ACP Group. Prior to entering politics, he was a university lecturer and has published numerous academic articles and monographs in public finance, public sector economics, agricultural economics, science and technology, as well as debt rescheduling and management. In the latter regard, he was associated, for example, with the first successful debt buyback and rescheduling of commercial bank debt under the aegis of London and Paris clubs, as well as the first ever program for the clearance of arrears to multilateral financial institutions under the so-called intensified collaborative approach for chronically indebted countries, which set the scene for the country to be a beneficiary under the HIPC initiative. Mr. Greenidge has held a number of key ministerial portfolios, such as foreign affairs, finance and planning, as well as trade. He has also served as the SG of the ACP Group of States in Belgium, the director of the Technical Center for Agricultural and Rural Cooperation in the Netherlands, and the director of the CRNM in Barbados. Mr. Greenidge is a former president of the ACP Group of States and co-president of the ACP EU Council of Ministers. He has also served as chairman and vice chairman of numerous European international boards, including the European Center of Development Policy Management in the Netherlands, also on the UN committees and the advisory boards of both the Regulatory Policy Institute and the Regulatory Policy Research Center, Hertford College, University of Oxford, UK. Ladies and gentlemen, I present to you our feature speaker for this evening, Mr. Carl Greenidge.
I thank you very much, Madam Moderator, for that introduction. Mr. Andre Henry and colleagues from the college, I wish to start by thanking you for this invitation. I'm really appreciative of the opportunity to address what is a current and very problematic issue for Guyana and the region. And in truth, many people who, even in Guyana, believe they are familiar with the issue tend to have acquired information on part of it, and over time have perhaps lost track, particularly because it is an issue with a history. It's a issue with a long history, not in the sense of having been a dispute for an inordinately long time, but for part of the time it was in existence, it had actually been resolved, as indicated earlier. Up to 1962, following the 1899 arbitral award, the matter had been resolved, and it has subsequently been reopened with the sorts of consequences that we've seen recently, and it has been taken to another level now with the attempt by Venezuela to find a mechanism for incorporating an area of Guyana that amounts to something like 74% of the land territory. And I'm not going to say anything about the maritime zone, because the 1899 agreement and the Geneva Agreement didn't address the maritime side. It has to be dealt with, but I'm not going to deal with it in this context because things are complicated enough without that. For the moment, let me say, and can we move to the next slide? Let me say that what I'm going to attempt to do is to give you a bird's eye view of some of the key issues around which what was called the controversy aims. The first thing I would like to show you by way of the slides is the map. Slide 1. Right, okay, that's the organization of the presentation, and if necessary, I'll come back to it. But as you can see, it covers a range of things. I want to say something about the ICJ process and the import of the ICJ, because I think most people who follow it are puzzled. Maybe they'll understand why we're at the ICJ, but they're not necessarily understanding why the process is taking so long and what are the different steps involved. And if I can help you to understand that, I think we can move forward together. The next slide is the slide that was agreed or has been devised on the basis of the map of 1905 that was agreed by Venezuela and the United Kingdom or Great Britain in 1899, and then it was followed, as you would have heard, by the delineation of the borders on the basis of what had been agreed by the parties, the technicians and land surveyors representing the two sides. That is the map that Guyana uses up to today, except for an adjustment that was made in 1903 and subsequently to accommodate an agreement with Brazil. Okay? But the basic shape of the map is the one that you know. Can we have the next slide, please? Right. That's just to enable you to see the context. Guyana to the west of Suriname, Venezuela to the west of Guyana, and the Caribbean territories to the north, northeast, and so forth. Can we have the next slide, please? Now, in the definition of borders and boundaries, certain criteria have become commonplace. They've become widely accepted. And what I want to say here is that in the case of Guyana, there are one or two peculiarities. But basically, in this part of the world, meaning South America in general, you had the influence of the papacy. And so that's the first one which is mentioned. Pope Nicholas V, in his papal bull, assigned to Portugal and to Spain territories. In addition to that, or as an alternative, the criteria could be conquest or effective colonization and agreements, but those agreements can't be unilateral. They have to be reinforced by international recognition. This is a very broad brush approach. And what I'm trying to say to you is that in the case of Guyana's boundaries, they have been arrived at by these processes that are set out, including the, in global purposes, the peculiar one of the Papal Bull. In 1648, when the Netherlands or the territories that constituted the nation states that made up the Netherlands at that time, when they had finished fighting what was in effect an 80-year war of independence against Spain, there was an agreement, the Treaty of Munster, within the Peace of Westphalia, that identified for the Netherlands or Holland not only the state itself, but the colonies that it had control over. And those colonies specifically that were identified would have included, or did include, Demerara, Essequibo, and Berbice. At that time, in fact, the Essequibo was probably the one that was doing best financially. But what I'm trying to say here is that an agreement between Spain, no Venezuela, of course it wasn't independent, between Spain and the Netherlands, arising out of a larger military confrontation, led not only to the independence of the Netherlands, but also they enabled the three colonies I named, which included Essequibo, to go with the Dutch state. And subsequent to that, you've had other things happening, and the most important of which was the ceding of these three colonies in 1814 to Britain after the Dutch again lost, the Dutch were involved in a war which they lost. They were part of the forces on the Napoleonic side, on Napoleon's side, and therefore they had to cede these three territories and others. Subsequently, you had the Treaty of Washington. These were mentioned before, so I don't want to go over those again. I want to say to you, it is a fact that there's been a long history of Essequibo's existence outside of any reference whatsoever to Venezuela. And you will see no reference to Venezuela here because it has never been part of Venezuela. Even when the Pope had assigned it, as it were, to Spain, what then happened, the Dutch being the major naval power rivaling Spain, the Spaniards were unable to give effect to that. And therefore, the result was that the Netherlands was able to occupy and develop Essequibo, Demerara, and Berbice by various means. I don't think that needs to detain us now. In some cases, you had the Dutch West India Company. In other cases, private companies like Van Per were given the right to exploit and develop these places. I just want you to know there's a background, and the background had nothing whatsoever to do with Venezuela. So that is important. When people draw parallels with elsewhere in South America and tell you, well, you know, there is a formula that says if the colony was governed by a certain colonial power, when it gets its independence, the borders will remain as it was before. That may be true of the Spanish territories, which didn't formally change shape after independence, but it isn't true of Essequibo. Essequibo became in 1834 part of British Guyana. The three colonies were put together, and they are governed by that relationship. So Essequibo itself has never operated independently of the other three elements that remain Guyana today. When it wasn't Essequibo standing on its own as a colony, it was part of what was called the two rivers, that is Demerara and Essequibo. But enough of that. Can we have the next slide, please? The point I want to make here is that a number of treaties associated with those changes, the others have gone through the history. Again, I don't want to go through that. But just to draw to your attention that there was international recognition associated with the movement of Essequibo and its two neighbors by the international community. Those are set out in the top indents before we get to the 1895-1897 treaty and the Paris Award of 1899. Those I don't want to explore. What I want to say to you that it was these things, these agreements and events that defined Essequibo and has it identifiable in a sense in the international arena as a separate entity of some kind. But it was never actually an independent entity. It was always a colony, and in being a colony, it was linked to the others. Now, if you skip that, that as it were, ancient process by which Essequibo evolved, the other documents that are relevant or events and treaties that are important to Essequibo have to do with the Treaty of Arbitration. Dr. Kurt mentioned the significance of that treaty. This is a treaty that set out the rules under which the arbitration of the borders between British Guyana and Venezuela were to be defined. So that is one. The UN Charter is another, and the Geneva Agreement is the third. And the Geneva Agreement is what we will spend a lot of time on after this, and is what any pronouncement made by Venezuela purporting to seek to resolve the difficulties between Guyana and Venezuela, what was called a controversy for reasons which I'll explain in a minute, they always quote the Geneva Agreement. It is important that if you are interested in this matter, you should keep a copy of the agreement. You can get it on the internet. It's a mere 4 pages. And unlike most legal documents, with all apologies to Dr. Bess, it is intelligible to a layman. And it is not terribly long. I said 4 pages, but the first page is the title. And I draw your attention to that title. This is what it was. An agreement to resolve, we can go to the next slide, to resolve the controversy over the frontier between Venezuela and British Guyana. Signed in Geneva, 17th February, 1966. That is an agreement to resolve the controversy. It is not an agreement to have a new border. It is not an agreement to move Essequibo from one dominion to another. In fact, it mentions no Essequibo whatsoever. Nowhere will you find Essequibo mentioned. Nowhere will you find a change in territory mentioned. Okay, so that is one. It gives you an idea. If you listen again to our neighbors, you will hear all sorts of things which are not encompassed in the Geneva Agreement. In other words, for our purposes, these are figments of their imagination or things from their wish list. The UN Charter makes reference specifically in Article 2.4 to the undesirability in the international community of seeking to expand territory unilaterally and by force. That's what that article is about, and that is really why I put it there so that you can be reminded. The other agreements which are mentioned there have been mentioned by my colleagues, so we can move to the next slide now, please. The Geneva Agreement itself. This agreement is much misunderstood and much abused. Much misunderstood perhaps by other observers, but much abused by our neighbor in Venezuela. It was signed in 1976. In 1966, as indicated, at a time when the British and Guyana were afraid that Venezuela had set out on a path to seize Guyana's territory after independence if, before independence, the British did not give them an agreement that allowed them to have Essequibo. That was the logic behind the Geneva Agreement. And it is an agreement that sets out the following things. It explains the reason for the agreement. I mentioned that to you. The term that it uses is controversy, not dispute, because the agreement of 1899 was about borders. And as was agreed in 1897, the parties agreed that would be a full, perfect, and final settlement. So the question of dispute didn't arise, hence the use of the term controversies. It's also set out the role of the UN. I mention this because you will see some very serious and visceral attacks on the Secretary General, as though he woke up a morning and just decided that this matter should go to the ICJ when the Geneva Agreement said something else. That is not the case. So the role is set out in the Geneva Agreement. It provided at the very beginning, that is, Venezuela announced at a UN decolonization committee meeting that it wouldn't respect the agreement it had signed. And then the 1966 agreement provided for a mixed commission, first of all. That is, dialogue between the affected states. And the intention at the time, and I'm saying this because this is what the British ambassador, who was party to those negotiations at the time, indicated at the time, so this is documented, that the intention of the mixed commission, the intention of the dialogue, was to assuage the concerns that Venezuela may have had that had given rise to its announcement that it would not recognize, it would no longer recognize the 1899 award. That was the purpose. That was the purpose agreed by the two sides, and that was what the mixed commission was supposed to do. And the mixed commission had provision for technicians from both sides. So the British had technicians, including Guyanese technicians, and the Venezuelans had technicians. And at the end of 4 years, non-stop discussions, they did not find common ground. And in other words, that also means that Venezuela was not able to point to anything that suggested that a fraud that they had hinted at, which Malay Prevost had speculated on, did not exist or could not be found. In 1966, after the agreement was signed, the two parties met in the mixed commission but were unable to arrive at any agreement as to how they would go forward. Okay? And so you had cause for others to intervene in this exercise in a bid to lower the tensions and go forward. The mention of the role of Dr. Eric Williams has been drawn to our attention, and eventually the Secretary General, in a bid to break the deadlock, proposed the use of a specific good officer. So he, as Secretary General, was given the task of trying to facilitate an end to the controversy, but in order to do that, he needed agreement from the two parties affected. The two parties affected eventually had to accept and agreed on, after the moratorium, an officer who would act as the good officer in this context and help try to facilitate. But before I go there in the operation of the good officers, let me draw your attention to certain things in the Geneva Agreement. Article 1 we've looked at already, so can we see the next slide, please? you will see that Article 4.2, it's making reference here to the role of the Secretary General and the two parties. So you had the mixed commission, you can't agree on the next step. There is, in Article 33 of the UN Charter, a number of means, it's called, for resolving. Those means actually could not have been used because the two parties wouldn't agree on them. And so what the Secretary General did was to find another means. The process is that he should go on and on until the controversy is resolved. And what he did in that case was to identify an outstanding Caribbean person acceptable to both sides to undertake a process of trying to get them to arrive at one common point. I'll come back to that in a second. The UN Charter, Article 33.1, is the charter that sets out the specific mechanisms, specific means to be employed. And if you look around line 4, you'll see the solution should be by negotiation. That's the first. By negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement. Resort to regional agencies or arrangements or other peaceful means of their own choice. Now, in the end, a peaceful means of their own choice was the good offices, okay, which ended with Dr. Norman Gervin. But one thing you should note, if you can find in that wording any suggestion that all of these mechanisms be used or that they should be used in sequence, then you are better than the lawyers that Venezuela and Guyana employ. The Venezuelan government has been saying that the Geneva Agreement says that all of these the means should be used in turn. I invite you to draw your own conclusions there, and also to draw your attention to what there is called the judicial settlement, because when later on the Secretary General was approached by Guyana to say, look, we've had enough of all these good offices, because whilst the good office process was in place, we lost Ankoko, as Dr. Curtin explained to you. The Venezuelans were contending that you could not find that they had agreed to the International Court of Justice. The highest level of judicial dispute settlement within the UN system is, of course, the International Court of Justice. Okay, it doesn't say the International Court of Justice, but that is what that is. Okay, so let us go to the next slide, please. So the question is, that is how you moved from a mechanism in 1966 that said mixed commission to how you got to the ICJ. And I tried to explain that there. In 2015, again signaled earlier, the two presidents met before the Secretary General of the UN, at which point they were both contending that they needed to move from the good office process because it wasn't working. Initially, that's what they both said. Guyana was adamant that it wanted to move because whilst it had spent those years from 1966 until 2015 following a good offices process, Ankoko had been stolen, and the conflict, the controversy was becoming a conflict in a sense, because there were now attempts by Venezuela to appropriate the maritime zone, the maritime space, okay? The Secretary General said that, and so Guyana was calling for some mechanism that would bring the controversy to finality, to end it. Venezuela, on the other hand, in before the Secretary General was saying that we should continue the good offices process because they saw nothing wrong with it. And this was what President Maduro said to Secretary General Ban Ki-moon. Ban Ki-moon said, look, this is a legal issue. If you have an arbitral award by an international panel accepted by both sides, and now one side is saying that it is not accepting it, it becomes a matter for the courts because it's a quasi-judicial panel that took that decision. They were all judges, in fact, former judges. And the Secretary General, however, recognizing Venezuela's insistence, accommodated them by saying we'll have one more year, a final year of dialogue. That was 2015. That is what he did in December of 2015, November of 2015. And he then turned to find someone else other than the Caribbean persons such as had been used before to facilitate the process. Venezuela's contribution to that exercise was to refuse to accept any of the names that were suggested, and in fact, the president of Venezuela offered to interview whoever was chosen, whoever was identified before they could be chosen. So the Secretaries General eventually did what is indicated in the last indent. Ban Ki-moon was going out of office. Gutierrez had been elected and his turn was coming, and the two of them, as far as I could see, collaborated on this exercise as regards the next step. And you will see that, well, I've skipped a step. They did in 2016 appoint Ambassador Doug Newlander, who was a Norwegian that had worked with Venezuela and Colombia in the problems between Venezuela and Colombia, and he took on the task of trying to get the two sides closer together. The Secretary General wrote to the two presidents saying, look, this is where we're going. He had what was called the way forward. He had a proposal called the way forward, and indicated to them that this process would be called enhanced mediation under Doug Newlander, and hopefully that would end things. But recognizing the difficulties that the two countries had in the past, arriving at any bilateral decision, he then sent the part that is highlighted to the two presidents. I didn't see what was sent to President Maduro, but I can tell you that the one that went to President Granger read as follows. If by the end of 2017, the Secretary General concludes, and he's concluding now with the assistance of Doug Newlander, who would work and present him with a written report. If by the end of 2017, the Secretary General concludes that significant progress has not been made toward arriving at a full agreement for the solution of the controversy, he will choose the International Court of Justice as the next means of settlement. That was sent to the two presidents, and yet one has been saying that they never agreed to the matter going to the court. But I invite you to the last clause there. This was not unconditional. He said, unless your government and the government of Venezuela, that is, unless the two governments jointly request that he refrain from sending the matter to the court. I hope that's clear. It is very clear to me, and it is hard to understand how with any goodwill one could say that Venezuela never agreed at any point to go or to have the matter sent to the court. These are the elements that contributed to it being sent to the court. Can we have the next slide, please? No letter was sent by the two presidents to the Secretary General of the United Nations. This slide we can skip because we've done it before. So can I have the next slide, please? And let me say to you that in the case of Guyana, and this has been mentioned before, the reason why it was also very keen to go to the court and end the process that had been good offices, apart from the loss of Ankoko whilst they were busy speaking, were that a number of incidents were taking place. Some of these were mentioned, but I want to add to those, because they were mentioned by both speakers before me. The resort to extraterritorial measures were also causing alarm in Guyana. Leone Decree was mentioned already to you, but there are a series of others that are there which are illegal. Venezuela itself has drawn to the attention of the United States what it calls United States tendency to pass domestic legislation and then treat it as though it was international legislation. Well, this is a case of decrees. These decrees were passed by the President of Venezuela and laying claim to the maritime zone. I mention this because it has significance. We're not dealing with the maritime zone. The court isn't dealing with the maritime zone, but it is significant. I'll tell you why. Can we have the next slide, please? Those decrees together, beginning with a decree in 2015 when Exxon discovered oil, those decrees had the effect of saying that maritime space, which these territories I name here, regarded as their own territories, either territorial sea or the maritime zone, exclusive economic zone, were henceforth Venezuela's territory. That in effect is what the zone says. It put it a little differently, saying that they're appropriating it for purposes of Venezuela's defense. It's like a man seizing your house or your bedroom on grounds that he had to keep his sitting room safe. And in order to do that, he's laying claim to your, yes, that too. And so, these are the titles under which the maritime zones of our countries have been named as Venezuelan property. You will see Barbados there, Guyana, Suriname, St. Kitts and Nevis, Montserrat, Dominica, blah, 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 all of those. I don't have to read them for you. I will say to you, when Colombia reacted to the decree in their own way, and eventually Venezuela took Colombia off the list. But all of these other countries, including St. Vincent and the Grenadines, remain on that list. Yes, the list, the original decree, 1787, was modified, but it wasn't modified in a manner that made any difference whatsoever. The same territory was still not only Venezuela's, but the Venezuelan Navy was charged with expelling others from those territories. Next slide, please. I put this up just so that you can see the distance from Caracas to the territories that Venezuela was laying claim to in respect of that last slide. You see the distance, 1,124 kilometers from the boundary with Guyana, Pointe Playa. That is the boundary between Guyana and Venezuela. Pointe Playa is let's say 350 miles roughly from the rigs that are operating on Guyana's EEZ. Okay? So that is the closest point of Venezuela to these territories. The rigs that are now operating, the closest one is 76 kilometers to Suriname. Why am I making this point? I mean, it is not Suriname that is complaining or claiming that their territory is being spoiled, but a country, the capital of which, and most of whose territory, is thousands of miles away. Next slide, please. So these are the things I'm saying that caused us to now move to the ICJ. Bear in mind, as I said before, the Secretary General was to choose from a list. He exposes those means on the list to the two countries. The two countries, as I said, have never really agreed on anything, notwithstanding what Mr. Maduro said. They have never agreed on anything, and of course, each of them blames the other. I don't want to bother with that now. But I want to say to you that when the Secretary General decided that the matter should be referred to the court, Guyana was pleased for the reasons that I mentioned earlier, and that is because it has been trying for all the years from 1962 to now to find a way where the matter would be resolved and Venezuela can't just reopen it. Every morning a president awakes and finds that he needs to mobilize public support. And that is why Guyana was so insistent that a judicial resolution be found. So when the Secretary General then decided, as he was empowered to by the Geneva Agreement, when he decided to choose from that list, Guyana moved very quickly to send the complaint to the court. That is the process. And that complaint was sent. We sent the memorial on April 18th, 2019, and that process that we had longed for so long then was in train. Next slide, please. The court now has a process. It's not all set out there, but you'll see it later. The court has a process. And the process that the court uses is the subject of dispute by Venezuela. I want to make that point clear. This is the rule that everybody else has been using, but they find somehow the process doesn't meet with their approval, and if you pay attention to some of the comments, it somehow discriminates against them. But the first thing the court has to do is to satisfy itself that it is authorized to look at a complaint that goes to it. And this comes under the title of jurisdiction. They were asked the law, and that's not peculiar to this case. Some people say, but why you have to go and do that? It is because that's the rule. If the two states don't agree on something and the matter has to go to the court, there has to be proof that at some point individually they agreed that the matter be referred to the court. And that is what is being said here. The court looked at the matter. It saw the very things I showed you. Article 4 of the Geneva Agreement, Article 33 of the UN Charter, and it was able to look at the letter that was sent to Venezuela and Guyana, and nobody could give them a letter from Venezuela and Guyana saying, we don't agree. That is it. The court therefore decided it had jurisdiction. And that notwithstanding, you will find Venezuela continuously contending that the court has no jurisdiction. Only Venezuela can decide whether the court has jurisdiction. Well, what the court is saying is that you cannot agree when it's convenient or when you want to keep others quiet. You cannot agree to come to the court. And then when it is inconvenient, your case isn't looking so good, you then seek to deny that you had taken such a decision. This is what makes this case quite remarkable. The other element is the size of the claim that Venezuela has. None of the other claims that you see, either a country wants to take over another, or it will want a 5% or a 2%. Venezuela wants nothing less than 3/4 of Guyana's territory. Territory that it has never governed. So, these are areas of disagreement. One is Guyana saying there is no land dispute. Why is there no land dispute? Because the matter was resolved in 1899 and Venezuela agreed, its National Assembly agreed, Guyana's agreed, its sponsor, which was the United States at the time, agreed that this was a fair conclusion, all of those things. Okay? Now we have a problem of the interpretation of Article 4 of the Geneva Agreement, which is why I say always keep a copy by your side if you want to follow what is going on. The contention, for example, that the Geneva Agreement says, as Dr. Bess was indicating, that you can only solve this problem by having bilateral discussions. I have the agreement here. It says nothing of the sort. Nowhere in the agreement does it say that. Article 1 is a general article about the purpose of the agreement itself. Article 2 speaks to the appointment of the members of the Mixed Commission. And if you continue to Article 5, it is all about the Mixed Commission. The Mixed Commission, remember, had a 4-year life, okay? That ended a long time ago. We get references from Venezuela often to Article 5, in which it says that neither country can, and they often forget this, expand its claim, or that they shouldn't. And it is also Article 5, which says that to facilitate the greatest possible measure of cooperation and mutual understanding, nothing contained in the agreement shall be interpreted as a renunciation or diminution of the claims made by the two parties. And then it goes on to say what economic or physical activities can take place in this space. I'm telling you this because this all pertains, this Article 5, it all pertains to the Mixed Commission and the life of the Mixed Commission. This is how the Geneva Agreement jumps. It goes Article 1, 2, 3, 4, 5. All of that is about the Mixed Commission. It has nothing to do with 2023. It gives no rights to Venezuela to veto development in Guyana. It doesn't say that in order for Guyana to put down a space station or a military base, it must ask Venezuela's permission. This would have been absurd. This is an independent country. It's about to get independence. Why would it sign an agreement with a neighbor that is so restrictive and constricting? It didn't. This is the agreement. It says nothing of the sort. And Article 6 continues. It's still about the Mixed Commission. The Mixed Commission shall hold its first meetings. That's Article 6. Article 7 talks about when the agreement shall come into effect, and Article 8 says upon the attainment of independence. It has nothing to do with the things that Venezuela keeps referring to. In the document that is to be provided to the voters during the referendum is a reference to acting on incorporating the Essequibo in accordance with the Geneva Agreement. That's what it says. The question, Essequibo is not mentioned in this agreement. And of course, Guyana would have been completely bonkers to sign an agreement talking about or setting out the mechanism whereby 3/4 of its territory is to be absorbed by Venezuela, and that it agreed to such a mechanism. It never did. And this is an era where people say you have your own truths. And it seems that our partners in this discussion embrace that approach, because the Geneva Agreement says nothing of the sort. It is an agreement about the peaceful settlement of the controversy. That is also in the subtitles, the peaceful settlement. So we go to the court, and that is the background, where the power of the court is being challenged, where whether there's a dispute or no dispute or controversy or what, that is also, notwithstanding what I've shown you, and the fact that judicial settlement is mentioned, still Venezuela continues to protest. Can we have the next slide, please? The application that Guyana made, and this is important because people often ask, is Venezuela going to take away Essequibo from us? Is the court going to give the Essequibo to Venezuela? Well, I can give you the assurance. the court has not been approached for the transfer of territory from any place to any place. It has been asked. The 1899 agreement signed by the two parties, does that agreement still stand? Is it valid? Because if it is not valid, then Venezuela has an opportunity to question its validity and for the things that follow. But if the two of us go to court, and the court, in a municipal court, decides on a settlement between the two of us in which he gives me your car and he gives you my house, let us say that's the settlement. Can you actually anticipate that you can wake the next morning and say, the court's decision is invalid, I will keep the car, which is what the court has said I can keep, but I will also take your house? This is inconceivable. The court has made a decision. You don't like the decision, so you are now implementing the decision that the court took, as well as the decision it did not take, a decision it did not take in your favor. That is what we are confronted with by Venezuela, when it is calling for the Essequibo. And do you know what makes this most grievous? In 1899, when Venezuela submitted its own arguments among some 6,000 pages, that's the size of the documentation that went to the court. The focus of Venezuela's claim was on the Orinoco. It was on the river Orinoco. Why? Because it wanted to have strategic and complete control of the Orinoco River, which is a far more massive river than the Essequibo. It sits at a junction which controls international trade, as does the Suez Canal, for example. A lot of trade passes south of Trinidad and through that passage. And that was their concern. And they went to the United States to get the United States to press Britain, to force Britain to go to arbitration. Arbitration was successful. Britain, on the threat of force by United States, agreed to go to arbitration because they were fighting, like all colonialists, too many battles at the same time. They decided they couldn't take on another one. Okay? You had South Africa and elsewhere. And they decided they would go to arbitration. But you know, the Minister of Foreign Affairs, who was a lord at the time, is asking, I have seen statements by Venezuelans. Is it going to be the case that when you get a decision you don't like, you will say that your constitution doesn't allow it? That was asked of the Venezuelans. The Venezuelans answered, do you know how? No. We will implement the decision. That was in 1899, and even before, because this was in 1897. Today, because we are all supposed to have forgotten, expected to have forgotten, they can go back on their word and now be attempting to do what is really quite outrageous. So the application before the court asked the court whether the treaty is still valid, and if the treaty is still valid, does it mean that Venezuela and Guyana have to respect the boundaries of 1899? That is what we were asking the court. We didn't ask them anything about the maritime zone. We didn't ask them anything about whether this piece of territory was Guyana's or not. Because if you've signed an agreement, and the agreement has all those details, once the agreement is valid, then the other things follow. And that is what the lawyers asked. Now, some things the lawyers didn't agree to. They said the Geneva Agreement was signed in 1966, and since it was signed in 1966, some of the things that you mentioned, including Ankoko, came after 66, so we don't have anything to say about it. So Venezuela was able to use military force to acquire territory, and the court has nothing to say about it, at least at this point. And the court went on to say that anything that took place after 1966 in the context of the discussions we're having will not be addressed by them. For Guyana, this was a success, to the extent that the court can now confirm for the world that if you sign an agreement, you ratify the agreement, you implement the agreement for 63 years, where we found villages with a border running through the villages, separating families, with a boundary on a hillside running through a stream or a river. As early as 1907, Venezuela was asked to agree to the modification of some of these boundaries, because now that you go on the ground, you find that they're inconvenient. Venezuela refused. I don't know how many times Venezuela has refused to modify the boundaries, and now they say they don't recognize them. If they didn't recognize them, why would they refuse to have them modified? So that is where we are. The boundaries could not be modified for 63 years. And then one morning, Venezuelan representatives woke up and decided that they're going to change all of them. Except that you cannot unilaterally change a border. If the old agreement defining the border is no longer in place, you have to negotiate a new one. And if it is an agreement affecting two sides, the two sides have to agree. You cannot wake up a morning and seize territory on grounds that you don't like what you're being given, and that the new border you define is what must apply, because that is what we're faced with. And you're being asked to come and talk. What is it we're to talk about? If in 62 years or more you have not been able to conclude any sensible arrangement, even agree on means, why would you agree simply because President Maduro has now decided that you must agree? Of course, he has military at his disposal, and that is part of what gives him the spunks, as Guyanese would say. That's what gives him the spunks, to be so ridiculous. Okay, so that is the application. If you have the other slide, please. I just want to set out for you the ICJ process so you understand, because I keep getting asked, why is this thing taking so long? The process, as I mentioned, you had the jurisdiction phase. Okay, whether in fact Venezuela or either party or both parties had agreed to the court. I'm not going over that again. The court decided that there was jurisdiction. The court decided that Venezuela was wrong when it said that these things I showed you didn't commit them to accepting the court's decision. After jurisdiction, we should go to the merits phase. That is arguing the substance of the case. In trying to argue the substance of the case, Guyana has submitted a memorial. The memorial is the arguments on behalf of Guyana, arguments saying the treaty is valid, and it is still valid, and running through the history that we know of the territory, its relevance to Guyana, and its irrelevance to Venezuela. Venezuela waited until the day before it was supposed to submit its own memorial, and it lodged an objection. It is within the rules of the court, so that's not a complaint. But it submitted its objection at the last possible minute. And that objection was heard in November of 2022. The objection, in essence, was rejected by the court. The objection was a procedural one. As I say, you got substantive differences as well as procedural differences. So the court decided in November that the preliminary objections lodged by Venezuela were not acceptable. it's a bit more complicated than that. You got all sorts of funny things like the precedent in relation to what had happened elsewhere about who is responsible and liable and so forth. The court decided when Venezuela's arguments were elaborated that Britain, as the country that had signed the agreement in 1899 and had signed the Geneva Agreement, both Guyana and Britain signed the Geneva Agreement in '66, but Venezuela is arguing that Britain should be at the court. And the answer, the response of Guyana was simple. Guyana is an independent country, Venezuela is an independent country. Are you arguing that Guyana's borders must be defined by the colonial power, a former colonial power, another country? It is they who must determine, it was they who must have a casting vote, it was they who must take that decision. The court rejected that. Okay, so that phase was finished. And now when many people were thinking, well, yes, we can go forward because that procedural matter was out, up comes Guyana and asks for the court to look at another matter. And that other matter is arising from the referendum. And the problem with the referendum, if I might be as quick as I can and simple as I can, it's not that you are saying Venezuela can't have a referendum if it wants to. Okay? It is that that referendum substantively affects another country and another country's rights. And it substantially gives Venezuela powers in relation to Guyanese citizens. So some people had responded by saying, look, don't worry the referendum. A country can have any referendum if it wants to. But what you will note, as with the decrees, the presidential decrees pertaining to the exclusive economic zone, Venezuela has included in its submission to its public language suggesting that its armed forces should implement decisions. Okay? So this is what really prompted Guyana at this time to go to the court to take a decision on this matter. And it is now for the court to act. You would have heard the pleadings on our side arguing that this is existential. Of course, the court would know that Venezuela had already acquired by force, outside of the Geneva Agreement, Guyana's territory. And the suggestion that it is preposterous to suggest that Venezuela's army has ever crossed its borders to seize other people's land, it is just untrue. But it seems that one is at liberty to say anything to the international community because you are Venezuela, because you are popular, because Simon Bolivar helped to liberate countries in Latin America, and they should all be grateful, although they aren't, and that is why you had Gran Colombia fall to pieces. But they never liberated anywhere in Essequibo. He never set foot there. When you had the slave rebellions of Guyana, it wasn't Venezuelans that were shooting the slaves. When Damon in 1831 rose up with other slaves against plantation owners who were abusing them, it wasn't Venezuela that deported these slaves to Australia. Actually, they didn't get to Australia because Damon himself was hanged and the others were sent to Australia via Britain, and they were freed there. But what I'm saying to you, none of that process involved Venezuela. Venezuela is claiming that it had control of these territories. How do you have control of a territory? You were controlling Essequibo. Essequibo is rioting. You were nowhere around to quell the riots. It's other people who had the task of putting them down. Not that that makes the other people desirable, but it's just a fact. That was effective occupation, effective control of Essequibo. And the village in which Damon, who was the equivalent, almost the equivalent of Kofi as a national hero, in which this matter started was La Belle Alliance. I don't know how many of you here know a word of Spanish. I don't know any word of Spanish, but I know a little bit of French. And that is not Spanish at all. It is in Essequibo. That is the place. It is a village in Essequibo, and all the villages that you will look at, that were touched by that rebellion, you will see carry either Dutch names or French names. If you travel Guyana, you will find not a single Spanish name. If it sounds like Spanish, it is probably Portuguese. Not a single one. If you look at the names of Guyanese, you will find very, very many Dutch names. Very many Dutch names. You will find Amerindian names. And those Amerindian names don't include Esquivel. Now, the Venezuelans argue Essequibo River, it's a Spaniard who went there, and all these ignorant natives couldn't name the river. So this man named the river. He named it after himself, Esquivel. In fact, the indigenous population of Guyana has a formula for naming things. Berbice, which is where I come from, is the name of the Creole banana that is found all along the river. Demerara gets its name from the fact that it is more muddy than most other rivers you ever set foot on. If you jump out on the banks of the Demerara River, you'll find it exceedingly muddy, more muddy than the other two major rivers. And that's how the indigenous people named it. Essequibo has nothing to do with Esquivel. It is named after the fact that the river is extremely wide, it is full of rocks, and they named it as a place akin to a fireplace, because the fires that they built use stones. It's not peculiar to Guyana, but most certainly the name Esquivel has nothing to do either linguistically as a derivation, as a source of the derivation Essequibo. And this is what I'm saying to you. There are, in looking at the historical evolution of this story, such absurdities, such arrogance, such untruths, that often when we tell people who ask, what is really the story, they can't believe it. A country signs an agreement. Do you know there are at least 6 other agreements pertaining not to Britain, because they say, oh, Britain's terrible, as though one imperialist is better than another. The other treaties and decrees signed were signed by others. Essequibo was reabsorbed by the Netherlands. If you listen to the Venezuelans, you'd believe that Britain came in the 1790s, invaded, took away Dutch property, and it was really not Dutch property because it was Venezuelans who were there. Oh, of course it wasn't. But the fact is that the international community, there's an agreement, 1802, 1803, in which the rest of the world acknowledged that Essequibo, Berbice, and Demerara were to be returned to the Netherlands. In fact, the Netherlands farmers, the Dutch farmers, who were living in Essequibo at the time, did not want the territory returned to the Netherlands because the Netherlands was unable to mobilize sufficient funds to buy slaves and to get working capital to guarantee their prosperity. So there was a lot of pressure from Dutch farmers themselves for the British. Okay? I'm not telling you that the slaves wanted it that way or any other way, but I'm just telling you that one segment of the community had that interest. And yet here is somebody, here are people from outside of those boundaries claiming that it was theirs, and they're the ones who were in control. Can I, Madam Chair, my apologies for taking so long. Let me just say that in winding up, I just want to remind you that even before the 1899 Paris Award, both parties agreed on what they would do with the report on the settlement of the arbitral panel. We signed in 1966 a Geneva Agreement with some clear things which gives functions to the Secretary General, and it says nothing, as Dr. Bess was confirming, it says nothing about Guyana and Venezuela can only resolve this problem if they have bilateral meetings. In fact, our experience has been that the bilateral meetings have not resolved anything. And so that is the background. The court is called upon to make a decision about what they think about the nullity or otherwise of the agreement of 1899. And that, I think, is what frightens our friends to the West, because they have no case. They have never submitted. In 1966, when we were looking at the mixed commission, nor in 2016, 2017, when you had enhanced mediation with Doug Newlander, never, and even in the jurisdiction phase, when information could have been provided, Venezuela never took the opportunity to argue the case as to why the agreement was null and void. It is a result of two reasons. One, they had no such information, and two, a certain arrogance that could suggest, you just say the agreement is invalid, we are not going forward with it, but you don't have to tell anybody why it's invalid. A man alleges the agreement was fraudulent, but he had such conviction that he was right, that he waited until everybody else was dead who was party to the agreement. They were all dead even by the time he was supposed to have been dictating this letter to his colleague. And up to today, we don't know for sure whether, in fact, Malé Prévost ever actually dictated such a letter. We do not know. So the evidence does not favor a solution in favor of Venezuela. And if that is the case, you'll recognize that the games and the silliness that we see and the absurdities will continue. It means that Guyana has to be prepared to be fighting this battle for a long time and to be successful, even if the court, as I would hope, would rule in our favor, that you have still to be alert on the diplomatic, political, and military front if, as my grandmother would say, if cat isn't to eat your dinner. Thank you very much for your patience. Good night.
Thank you very much, Mr. Greenidge, Esquire, for that powerful presentation. If we did not grasp or grasp anything from what was said by Dr. Curtin and Dr. Bess previously, I'm sure that Mr. Greenidge would have sought to bring everything into confluence. He went right back into the history and came forward, spoken about all the different awards that would have taken place. Look at 1899, 1905, 1960, only dates, 1962, 1966, and even 2022. You know, all these different awards and agreement, you know, that would have transpired between Guyana and Venezuela. There was mediation, it involved the courts, and still today we still have, you know, disagreements taking place between Venezuela and Guyana. I must say that this panel has put forth strong arguments as to Guyana being right in their position. Given all the information that has been shared here, I hope that Venezuela could actually respond and, you know, shed some more light on this dispute that has been going on, to me, like it seems forever. You know, and at the end of the day, I believe that all that we hope for is an amicable relationship, or an amicable resolution between these two countries. I also took note that Trinidad and Tobago also played a part in this conflict, you know, and still today, you know, there is still this controversy that is taking place. So, with that said, and we know that we are running against time, I would like to open the floor. If you all have any questions, any comments that you would like to make. Any questions for the panel? There's a mic. Mic has been placed there. If you have any questions, any comments for the panel, you're free to engage. Dr. Henry?
Well, thank you very much, Dr. Henry. We are, let me say, we are working on the assumption that the court will give a just verdict on the matter before them. We have full confidence in the court, and we are aware, of course, that it takes time to do things, which is something that concerns the constituency. But outside of that, we are satisfied that the court will give itself a chance to understand what's going on and to rule appropriately. As regards Venezuela, let me say that generally with the ICJ decisions, I think they probably, I saw a figure of 170-something decisions over the years since it was established. Initially, there was a lot of resistance to implementing their decisions. And this had caused some alarm amongst members. But in recent times, as the chairman of the court, and I think the former chairman of the court emphasized, countries have begun to accept that there's a process. The process, by and large, is just, and the outcomes are reasonable. And I think one of perhaps the most notable cases of refusal to implement was in the case of Nigeria and Cameroon, to the point where the Nigerian presidents had said several times that they're not implementing any part of the decisions in relation to the disputed area. I think in time, we have seen Nigeria, notwithstanding such a strong position, moving to implement those decisions. And generally speaking, that has been the case. Now, whether Venezuela is going to act, whether it's going to act immediately, whether it is going to act comprehensively, I don't really want to speculate. What we are doing, what my task is, in the framework I'm leading, is to ensure that all the other mechanisms that can prevent Venezuela from ignoring, or which would justify them ignoring it with impunity, that those doors are closed. That is our task, and the diplomatic service, the Ministry of Foreign Affairs has that task, and of course the Rear Admiral can speak for himself from a professional viewpoint. But basically, we are aware that we have to do a number of things. The matter isn't going to be resolved tomorrow, even if the court decides favorably. And even if it doesn't use its military, there are things to be done to prevent them from thinking that that could be a costless exercise. And that's the task.
Thank you very much, our agent to the ICJ. I want to start by endorsing what Mr. Greenidge said. I think recognizing Guyana's position is heavily dependent on defense diplomacy and the expected decision in our favor from the ICJ. I know it would be resigning in many minds. What if, Dr. Henry, what if, is there a possibility of Venezuela crossing the border? In speaking as a former military, we'll always have a calculus that there's also a possibility of something happening. The extent to which the defense force will respond to that will be proportional to its resources and how it's trained to fight. The most important thing, I think Mr. Greenidge mentioned, is that this defense diplomacy is what acts as a buffer between Venezuela or any other nation state that is an aggressor against Guyana. That defense diplomacy commits that delay period for other international forces to come and work with Guyana. And that has always been our strategy going forward. So to be honest, yes, there's always a possibility. And I think the possibility is larger the extent to which the referendum remain active against Guyana, or looming over Guyana in my view. So the court's decision, which is a process, will take some time, is what we're going to rely on, along with our defense diplomacy. But there's always that little risk that between that time, there can be intervening variables. But Dr. Courtney mentioned that the whole issue of the Brazil aspect, that counterweight, so to speak, to Venezuela by Brazil, I think is very active. And we have an ambassador, I think, who's going shortly to Brazil, I think. So we expect that our diplomacy will kick in, increase, become more robust. CARICOM also playing a more meaningful role in relation to Guyana, and I believe we can pull through without having any conflict in the continent, without any conflict between Venezuela and Brazil. Thank you very much.
Thank you very much, Mr. Greenidge and Dr. Bess, for your response. Dr. Henry, that was helpful. Great to know. I have two questions here for you, for the panel. The first one is, considering the economic implications and the recent oil discoveries, how do the panelists, how do you foresee these factors influencing the trajectory of the Guyana-Venezuela controversy, border controversy? And are there potential strategies to balance economic interests with diplomatic resolutions? That I don't want to take the question. Could I
This
speak?
person here is British agent.
Madam Moderator, the fear of some observers, or the suspicion of some observers, is that the enthusiasm that Venezuela has found for prosecuting this attempted annexation is closely related to the discovery of petroleum resources in 2015 and their exploitation since. Development and production has been taking place since 2019, and actually the Exxon and its partners have been on a sort of what would be called in another context a roll. Very many discoveries of reserves of commercial quantities have been discovered. They have enabled Guyana to undertake investments and other activities that they would not otherwise have been able to afford. Of course, we have in Guyana a group of Caribbean people who are particularly, at times, seen partly combative. So you have major criticisms of the exploitation of the resource. You asked about the resource. I want to say to you that it isn't everybody that thinks it's a good idea. And there are those who feel that if we play our cards right, the world will provide us with resources in return for not exploiting that. But I don't think that very many people who are in policy-making positions are persuaded by that argument. And therefore, there is a drive for the government to put in place appropriate mechanisms to ensure that these resources can be properly exploited and effectively exploited, and that the revenues from them could be equitably shared amongst the populace. So that is also a part of the problem and contention that is taking place. There is a hope that we can see policies wisely implemented so that the Guyanese can benefit, and by them seeing the benefit from that sort of development, it can also enhance their own enthusiasm to deal with problems such as claims by Venezuela and anybody else. It is, I think, going to turn very much on the prudence and wisdom of the government in calling upon the skills available. It is, of course, necessary to understand that your capacity to persuade others to collaborate with you will depend, again, on the diplomatic effort, diplomatic thrust, and our first line of defense in the diplomatic sense has always been the Caribbean, and one would expect that continuing attention will be paid to ensuring that that Caribbean shield is effective, and I dare say that the benefits enjoyed from preserving and securing our resources can be shared with the rest of the region. That is my view.
Okay, thank you very much, Mr. Greenidge. You spoke about CARICOM. Since Venezuela is not a part of CARICOM, should CARICOM take a collective or play a collective role in this whole, controversy, this conflict that is taking place between Guyana and Venezuela?
Maybe I can exercise some reciprocity here, language used in trade disputes. You might want to refer to Dr. Curtin for part of the answer, but as I'm up, let me say to you, CARICOM has, as a whole, good relations with Venezuela. Okay? The region has come to Venezuela's defense several times when it was facing difficulties elsewhere, and many of the leaders of CARICOM are on good terms with Venezuela. It would seem to me that that is a basis upon which influence can be exercised with Venezuela. And let me tell you something which you may or may not be aware of. But in 2016, when the CARICOM heads were looking at the problem of Venezuela and its maritime decrease at that stage, the claim to the exclusive economic zones of 9 CARICOM territories was drawn to their attention. The CARICOM heads were reminded that this is not a problem solely about Guyana. It may be Guyana's territory today that is under threat, but other countries in the region, not the size of Colombia, without the cultural link to Venezuela as Colombia, are also are in danger. And therefore, CARICOM would do well to use its influence to attenuate any tendencies towards warlike and undiplomatic resolutions. In 2016, in fact, CARICOM heads instructed, can't remember whether it was the chairman at the time or the chairman and the Secretary General, to write a strong letter to Venezuela, which had attempted, President Maduro had attempted to participate in that CARICOM heads meeting. And the chairman was told, I think it might have been Barbados at the time, to write to Venezuela saying this is Caribbean patrimony, because they were made aware at the time that the threat was not only to Guyana, and that Venezuela should refrain from actions to try and seize resources that were not Venezuela's. That is a resolution you will find in the CARICOM documents and a letter sent to CARICOM heads. So CARICOM has not been insensitive to this problem, and even in that escapade, there was an attempt, I think, a reasoned attempt to use their influence to get Venezuela to treat with their concerns. And I would hope, notwithstanding some of the statements that one has seen recently, that CARICOM would recognize that. Because sometimes, sometimes our states forget, you see somebody in trouble, you think that's their business, but in reality, it's not the case. So, Dr. Curtin might help me out here.
Well, all I could do is reiterate my concern and my appeal, first of all, is for CARICOM to have a more robust kind of level of support. And I believe that facing this existential threat, CARICOM leaders should meet before the 3rd of December and to show unequivocal support for Guyana. At the same time, I believe that we should look at the expansion of the regional security system, as Dr. Bess has indicated, that we should look at moving from that small but effective in some ways RSS, regional security system, to a broader Caribbean regional security system. And that, I think, that must have the blessings and total support of all the leadership in CARICOM. So I also think that in terms of the Security Council approach, the Caribbean CARICOM must now ensure that at that level, we have a letter from all of the CARICOM member states collectively seeking to ensure that our position, Guyana's position, is clearly indicated at that level. So I think those are the immediate steps for me for CARICOM's role. Down the road, I would say that maybe we have to look at a re-engineered or restructured Petro-Caribbean, maybe broadening the input of countries that are now emerging in the oil and gas sector, like Suriname, Guyana, and even using Trinidad's existing facilities, so that you remove dependence on the smaller Caribbean states from one state, Venezuela, to a more Caribbean kind of petro-Caribbean. So those would be my recommendations for CARICOM at this stage.
Okay. Thank you very much, Dr. Kirkland.
Thank you very much. Just briefly, I don't know if I missed it, Mr. Greenidge, but I'm just going to endorse what Dr. Corden said, because I believe, and I want to look at it from a different perspective, because I believe the resources, the hydrocarbon resources in the offshore Guyana and Suriname, even though they are physically present there, I don't believe we should consider it to be Guyanese or Surinamese. It should be seen as a regional resource. And I think that might have been, if I'm being so bold, because I'm speaking here academically, a sort of a misstep on the part of the government of Guyana in maybe not sending a strong message that it has such an intention. I remember Trinidad created a fund, if am I correct, and we benefited from that fund in other countries. I think if we were to practice some petro-diplomacy, and this being led by Guyana at this point in time, and then perhaps by Suriname, it can serve to do what you suggest, reduce the dependency on Venezuelan fuel. I might not be correct, but if I may just, I think I understood it then that the reason why Trinidad could not outprice Venezuela, but was able to create a fund instead to assist other Caribbean states. I think we have to treat it as a regional resource. We have to be led by us in Guyana. This is a regional resource and all can benefit from it. So I do endorse it. And if you mention it, I'm sorry if I said it again. Thank you very much.
Thanks very much, Dr. Bess. Dr. Kirkland. Yes, sir, I recognize you. You have the mic.
Former Ambassador David Edge.
Thank you very much, Madam Moderator. First, I want to thank the panel for excellent presentation. I mean, very extensive. It was an educational experience for me as well. I have a couple observations / questions. I don't know, Mr. Greenidge, if you may choose to sidestep it. But I recall, well, this issue of the Guyana-Venezuela border issue, I'm not even getting into the dispute controversy business, has been going on for so long, and it has caused, in the evolution of relationships in the region, a sort of shifting sands, shifting alliances, where one country's position in support of one country at one point may not be guaranteed forever throughout. I recall some time ago when another administration, for instance, was in Brazil. If a challenge is made to the existing boundaries, other countries in the region are going to be affected, including Trinidad and Tobago. I speak of Brazil, who has, together with Guyana, a mutual interest in boundary delimitation with Venezuela. I recall some time ago in another administration in Brazil, Brazil had come out with somewhat a strong position in support of Guyana's position. Am I correct in remembering that? I remember recently with the Pink Tide movement and socialist governments coming into power in the several countries of the region, that, for instance, the articulation of position out of Brazil at this point didn't seem to me as strong as it did back then. Would you care to comment on any discussions that you may have had with Brazil, and what is the position of the Brazilian government in the evolution of this issue?
Okay, thank you very much. My research has indicated that Brazil has consistently supported the view that borders haven't been demarcated by judicial settlement deserve sanctity and are inviolate. I think that's been a case across the region, across the time span. Now, I think that over the years, we've seen that consistency in Brazil's relations with Guyana, even when the military regime types were in office. I saw where Brazil talks about responsible pragmatism as a foreign policy, a significant foreign policy platform on which they laid their framework for relations with countries like Guyana. So I haven't seen a change in the support for Guyana, even though one might have seen over the last few years not a very robust relationship any longer, in the sense that I think over the last 3 or 4 years, there hasn't been a very strong diplomatic representation, which always gives countries a little bit of a question as to the tenor of the relationship. So, but what I've seen over the last couple of weeks is reported in the newspapers and in the media generally, a return to dialogue with, and discourse with President Lula and President Ali. So I would hope that there is that kind of sustained engagement, especially since Brazil is always concerned about the border security, its border security. And I've seen where, over the years, for example, Brazil moving to something called the Calha Norte, the Northern Cordon program, and ensuring that the borders with Guyana are more, well, subject to greater military oversight. And I've seen something called SIVAM, Sistema de Vigilância Amazônica, which is a surveillance system which Brazil has ensured that the borders are continuously under some form of surveillance, and to ensure that the borders are protected. So I see a continuation in Brazil's support for the sanctity of borders, and I don't think that there has been a wavering, although one might argue that, in the context of the return of the pink tide and the return of President Lula, I could see a stronger effort to enhance the relationship with countries like Guyana. I mean, not only based on some similar interests, but in Brazil's quest for the renewal of the integration effort, which started under President Lula. And I could see the re-emergence of UNASUR, the Union of South American Nations, which basically was kind of frozen under President Bolsonaro, and the potential here for Brazil to reassume a leadership role in the hemisphere and in South America particularly. And remember also that Brazil is a BRIC. One of the BRICs, I think, is important in that context, that Guyana look to continue a strong link with Brazil, to be able to get that kind of support, and even for Brazil to act as a potential counterweight, as we talked about, to any aggression that Venezuela may want to move forward with in relation to its borders, to the borders with Ghana. But I think it's also necessary to note that Brazil has recognized that should there be any change in the borders between Guyana and Venezuela, it will impact their borders and how they will have to redefine borders with Guyana. because some of the region passes through territory claimed by Venezuela. So I think it would be important for Brazil, and I think it continues to be important for Brazil to continue to look at very strongly at that border issue. And we've seen where, over the years, there has been, and I think Dr. Bess could probably speak to that more than I can, that Brazil has also had military cooperation and training, as a matter of fact, since 1969. Brazil has supplied Guyana with kind of training for officers and other ranks in several areas. So they recognize that kind of commitment, the South American commitment, to ensure that you're both protected diplomatically and militarily. So I think it's multifaceted in the sense that Brazil is an important player, to my mind, in this controversy.
Okay. Madam Chair, just to contribute to that point, Brazil is also an important counterweight on the maritime front because Brazil was able to negotiate with France that maritime border of French Guyana. We have to remember that Brazil they had an issue, I think, with France. That's French Guyana. Then next to French Guyana is Suriname. So if you look at Brazil, not only on the land border side, on the maritime side, it has offshore hydrocarbon facilities. It's drilling for oil. So we can learn so much from Brazil. Yes, Dr. Corton, a lot of officers were trained. I was trained in the Brazilian Navy. I lived in Brazil for 4.5 years and trained in Portuguese. We've got a lot of officers who were trained. Continuously, they continue to do that. We've had officers trained in Venezuela, not as much as Brazil. And for that period, there might have been maybe a cooling off period. We thought that the relations were going to increase significantly because they were offering training and they were coming to Ghana to train. The Brazilians come to do jungle training in Ghana, we go and do jungle training there. So there was a movement really of rapprochement, I think you mentioned that, between Ghana and Venezuela. And somewhere along the line, maybe, I can't say specifically, but it changed. So yes, I think Brazil is that counterweight both on the land border side and on the maritime side. I think that, in relation to CARICOM, Ambassador, you would mention it, right? I know it's complex. That's why, for me, I mentioned if we were to try to look at it from an economic perspective and give CARICOM some assurances that they're getting from Venezuela, that could be a counterweight using Guyana and Suriname. And perhaps I did mention at least the appearance of the Venezuela might be one way, but I don't think it's on. And I'm going to limb here, strategic ambivalence of a CARICOM nation, understood by Guyana to mean, I have your back, but this is where I am right now. I mean, that's something that could be understood also. Thank you.
I was going to say, Ambassador, that I agree with you as regards the dilution of empathy that may arise over time. In other words, if the issue drags out for very long, people forget, they lose interest and so forth. But this is not something unknown in diplomacy. And that is why a country, especially if it's small, has to always maintain an active diplomatic stance. The things out there are always changing, but they often may not change in your favor. You have to be watching and adjusting and adapting as things change. And this is one of the things I think that really one has to try and emphasize as a Guyanese to my colleagues in the administration, that this is important. As regards Brazil, even if it is rendering assistance, does not often say a great deal, but it is a major power in the region and beyond as a source of soft power. It has a whole set of advantages for it that enable it to speak to other countries and require them to listen. Some time ago, when some difficulties with Venezuela started and somebody was suggesting that Guyana had agreed to or was proposing to agree to relinquish territory, which of course wasn't true. I remember the Brazilian minister saying to me, or one Brazilian minister saying to me, anytime you think of responding to that particular pressure, you let me know first before you do anything. Okay?
Yes, thank you very much. Anybody else from the audience? Yes.
Yes, thank you. My name is Arenton Chesney. I'm Guyanese, so let me first claim that. But I've worked in the region and Central America for many years. Let me say, by chance today I got a map predating 1899, and it looked like a pregnant Guyana. Relative to the Orinoco that we lost in 1899. Mr. Greenidge, I could share it to you if you don't have it. I know you have all of these things. Now, I could be less diplomatic than Dr. Bess and Dr. Gordon, but the response from the heads of government, not from the Secretariat, but the heads of government on this issue is very lukewarm. And I think we need to do much better as a region lead to do much better than that. Because if we lose again, we're going to lose Belize next from CARICOM. Right? So let us be very careful as to what we're doing on the Guyana issue. Thank you very much, Madam Chair.
Thank you very much. Any response from the?
We can agree.
Okay. Fine. Oops, we have two more questions. Last two, final two questions. Yeah, make it short.
Pleasant good night to panel members. My question is directed at any one of you guys. What the International Caribbean Court of Justice, do you have a timeline in which a decision must be made to resolve the conflict, or is it can be ongoing until both parties decide to come to some sort of agreement? Thank you.
Well, Madam Moderator, there is a deadline facing the court, or at least facing Guyana in respect of Venezuela's most recent actions. The question of the referendum and the time after the referendum in which they might want to act. But we don't know what is in Venezuela's mind, but that is a possibility. As regards deadlines, that is the only one. The court itself has acted very expeditiously in response to a request from Guyana, bearing in mind that that deadline is December the 3rd. Outside of that, there are no deadlines. The court has to satisfy itself that by examining the issues brought before it, it can do so properly. And they give no commitment that they will answer within a year or within 5 years or anything like that. But what we have to understand, and we try to be patient with them, because you're dealing with matters that are complex, and there's no appeal to the decision made by the court. So we do press them, but recognize that they have obligations that arise from that. And I don't think that, I don't think it's going to be feasible to say to you anything other than if the hearings are concluded, once the hearings are concluded, you will get a result from the court reasonably quickly. Reasonably quickly in the court's language could be 6 months to a year. Okay, in some cases they've done it closer to 6 months than to a year. But outside of that, it depends also upon the parties. So, for example, we would not have anticipated a Venezuelan referendum of this kind. And therefore, we might have told you, as I in fact have been guilty of doing in the past, say to people, oh, certainly by the end of 2024, we should be getting some answers. But you don't know. In one case, the country fired all of its legal team and then went to the court to ask for more time. The court was not persuaded. I don't want to mention the country. The court was not persuaded that this was a good idea and refused to give them any time of consequence. In the case of Mr. Dr. Chesney mentioned Belize. Belize also had a challenge in the court in which the Guatemala team was asking for extra time, which the court didn't feel justified. And they just asked them to meet the deadline that they were given. Kenya and Somalia had a similar problem. Kenya fired the entire team and then claimed that it needed the same time to reformulate its position again. So these are games also that countries play like they will play in the municipal courts, and you have to be careful, and the court has to be alert to this because its own standing and its reputation depend upon people believing that they're credible and that they're streetwise enough to see these games.
Thank you very much.
Last and final question.
Well, I must say that I enjoyed these presentations very much indeed. I've learned so much. Still recognize the fact that there are a lot of very bright people still remaining in Guyana, but I'm still over here, but was born in the mudland. Fortunately in the county of Demerara, really, so Essequibo should not bother me at all, nor Dr. Greenidge, who was born in Berbice. I want to ask a question. Is Guyana a member of the OAS? And if so, what are their views pertaining to this vexatious issue?
Yes, Guyana is a member of the Organization of American States, and the matter has been touching the OAS at various times in the past. In the past, this was not a good forum in which to get, from which to get a sympathetic response to anything that pits Anglophones against others. But what has happened, I think, in time, many of the regional institutions, and I'm not saying this to be malicious, there have been many problems within the regional institutions within the last 4 or 5 years. And many of those problems stem from Venezuela's behavior and refusal to accept decisions made by majorities in the group when the rule allows for it. UNASUR was mentioned by my colleague, Dr. Curtin. That was one example in recent times. So I suppose the truth is that I should add, sorry, that the OAS has actually had something very strong to say within the last 18 months or so. There have been at least 2 very, very strong supporting statements from the OAS, usually from the Secretary General. You know, if you're going to get a group as wide as that to agree on things that are contentious, it's always going to be a problem. But in terms of territorial integrity, I believe that they have delivered what they've been asked to deliver. That is the OAS, the Council. And I don't think at this point in time the government has any complaints about them. Venezuela has actually suggested from time to time that their chances would be better if the equivalent of the ICJ in the region were to try their case. But I, having had not as much experience with them as I have with the ICJ, doubt that too. They doubt that too, because some of the same dignitaries and judges end up at the ICJ, and they have standards to maintain, and the belief that you will just call upon language groupings on grounds that Mexico was abused or wherever. Who hasn't been abused by imperialists? That is what I ask. Where do you come from? Latin America? Where do you come from? India, Southeast Asia? All of us would have been victims of that sort of behavior. And you can't just react to an outrage by resorting to the fact that an imperialist was involved 100 years ago, and therefore you're justified in doing anything now. But you are right, we have to work with institutions that we are members of, and as small states, we have to be especially careful about nurturing our relationship with those institutions so that they can all embrace our causes. It means that we also have to pay attention to their troubles and assist them as countries and as regional groupings. Sorry to have taken so long, madam.
Thank you. Okay, so let me just say thank you to you, Mr. Greenidge. Thank you to you, Dr. Bess. Thank you to you, Dr. Curtin, for gracing us with your presence here this evening. And I would just like to call on Dr. Anatol Malon Anatol, our Dean of Research, to give some concluding remarks.
Good afternoon. Good evening. Well, okay, I'll go with evening. Good evening. Yeah, to give a vote of thanks. As a student of international relations, I have a lot of comments and I have some questions, none of which I can ask because of the restrictions of time. However, Dr. Curtin, Dr. Bess, and Mr. Greenidge, I would like to thank you for this presentation, which has been, for me personally, delightful, but also very informative, and it opens a range of the possible discussions that we could have at a later date. But as we do close, I know Mr. Greenidge has a presentation to give to Dr. Henry, our director, for 3 publications. I took a little peek at them. Very insightful, very wonderful publications. Dr. Henry, if we may, to ensure that it's handed over in the correct way. It has really been a delight to have such a distinguished panel. And I want to commit as a person trained in international relations, this has taken me back. And it was just very good to have been here. And I hope that this institution can contribute to some of the work that you're doing in terms of research and bringing whatever we can to the table. Thank you so much. Yes. Good night, everyone.